Welcome to International Trade Minute, Quick Fire Trade News, the essential podcast for today's trade professionals, presented to you by Rydell Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news, distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Rydell Law Firm, this podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify, and join our professional community on LinkedIn. Today, we are exploring recent developments in international trade, including CBP rulings, sanctions, wildlife trafficking, and new compliance rules for investment advisors. Let's get started. First up, in a recent ruling, U.S. Customs and Border Protection has affirmed its earlier decision regarding the classification of hand sanitizer dispensing stations manufactured in China. These stations will continue to be classified as other furniture rather than parts of mechanical appliances for projecting liquids. This classification has significant implications for importers. As products of China, these dispensing stations now fall under subheading 9403.70.40, subjecting them to an additional 25% ad valorem duty rate. The ruling stems from a protest by the Alchemist Group, who argued that the stations should be considered parts of mechanical devices for projecting liquids. However, CBP maintained its stance, stating that the stations don't materially change the dispensing machine's function and therefore can't be classified as parts. CBP's decision hinges on the fact that these stations are designed to be placed on the floor and provide a space for hand sanitizing. The agency emphasized that while the dispenser's main function is to project sanitizer liquid, the stations themselves don't contribute to this function. For trade practitioners, this ruling underscores the importance of careful product classification and the potential for significant duty implications based on these determinations. Up next, in a recent Senate Foreign Relations Committee hearing, witnesses advocated for increased use of sanctions and export controls to combat political repression abroad. Douglas Rutzen, CEO of the International Center for Not-for-Profit Law, highlighted the need for more effective use of the Global Magnitsky Human Rights Accountability Act. He suggested that the committee could exercise its oversight role to promote more robust application of these authorities. Rutzen also recommended considering transnational repression and the undermining of democratic institutions when determining sanctions. This comes in response to a concerning trend where 72 countries have introduced over 270 legal initiatives to restrict civil society in the past 5 years. Yakyu Wang from Freedom House proposed expanding the Bureau of Industry and Security's entity list to include Chinese technology companies responsible for human rights violations. She specifically mentioned companies providing surveillance systems used in repressive crackdowns in regions like Xinjiang. Wang also endorsed the proposed Transnational Repression Policy Act, which would sanction foreign entities and individuals directly engaging in transnational repression. She emphasized that sanctions are particularly effective against Hong Kong officials, who often have foreign bank accounts. Committee Chairman Senator Ben Cardin suggested that increased enforcement of existing sanctions, coupled with new tools like pending legislation to sanction Georgian officials, could help counter repression more effectively. For trade practitioners, these developments underscore the importance of staying vigilant about potential new sanctions and export control measures. It's crucial to closely monitor updates to the entity list and be prepared for possible expansion of sanctions regimes targeting human rights violators and those involved in transnational repression. In our next segment, we turn our attention to a pressing issue in international trade: wildlife trafficking. Recent reports highlight that this illegal trade remains a significant global concern, ranking as the fourth largest illicit trade worldwide when including fisheries and plant life. Alarmingly, rhinos, pangolins, and elephants are bearing the brunt of this illegal activity. These three species alone account for nearly 3/4 of all seizure records between 2015 and 2021. This concentrated targeting is pushing these animals dangerously close to extinction. What's particularly concerning for trade practitioners is the convergence of wildlife crime with other serious organized criminal activities. We're seeing frequent associations with money laundering, corruption, and tax and customs fraud. This overlap underscores the complexity of tackling wildlife trafficking and its far-reaching implications for international trade and law enforcement. Interpol warns that as this sector continues to grow, it's not just these specific species at risk. Their data reveals that a significant portion of trafficked mammals, amphibians, and reptiles are considered threatened species. For those in the trade sector, staying vigilant and implementing robust due diligence processes is crucial. Be aware of the potential for wildlife products to be concealed within legitimate shipments and stay updated on the latest wildlife trade regulations and restrictions. For our concluding piece, in a significant move, the Treasury Department has issued a final rule that will bring investment advisors under the umbrella of anti-money laundering and counterterrorism financing requirements. Set to take effect on January 1st, 2026, this rule aims to close critical loopholes in the U.S. financial system that have been exploited by criminal actors and sanctioned entities. Under the new regulations, investment advisors will be classified as financial institutions under the Bank Secrecy Act. This means they'll need to implement risk-based programs to comply with AML and CFT rules, file suspicious activity reports, and meet specific record-keeping requirements. The rule's scope includes SEC-registered advisors and those reporting as exempt reporting advisors. However, it excludes certain categories, such as mid-sized advisors and those without reportable assets under management. For foreign-located investment advisors, the rule will apply only to advisory activities within the U.S. or services provided to U.S. persons, or foreign-located private funds with U.S. investors. The Treasury has emphasized that this move will level the regulatory playing field and enhance the transparency and integrity of the American financial system. It's particularly aimed at preventing sanctioned parties, including Russian oligarchs, from accessing the U.S. financial system. Trade practitioners should note that this rule may require significant adjustments in compliance procedures and potentially in contractual arrangements with service providers. The extended implementation timeline to 2026 allows for these necessary adaptations. That wraps up our International Trade Minute for today. Let's quickly recap the key points. CBP's ruling on hand sanitizer dispensing stations from China may impact import costs. Keep an eye on similar product classifications that could affect your trade practices. The push for expanded sanctions and export controls highlights the need to stay vigilant in your compliance efforts, especially when dealing with potentially sensitive technologies or regions. The ongoing issue of wildlife trafficking serves as a reminder to ensure your supply chains are free from illegal wildlife products. Lastly, investment advisors should start preparing now for the new anti-money laundering compliance rules taking effect in 2026. Thanks for tuning in to International Trade Minute. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Rydell Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.